Welcome back to Breaking History, the Supreme Court Historical Society's show where we highlight modern scholarship about the Supreme Court's endlessly interesting past. I'm Ross Davies, and today I am joined by Professor G. Edward White. Professor White's first published work of Supreme Court history, it was about Justice Oliver Wendell Holmes, about whom he has continued to write for the past half century, was published in 1971, just before he started his clerkship with Chief Justice Earl Warren. Right after that clerkship, he joined the faculty of the University of Virginia School of Law, and he has been teaching and writing about the Supreme Court and many other things, from sports and torts to Alger Hiss and Owen Wister and on in an unending variety ever since, except when he is visiting and lecturing at schools around the world. But the Supreme Court has always been central to his work. His numerous books and articles about the court range from full-length biographies of members of the court to historical surveys to doctrinal studies to microscopic examinations of individual cases and events. Two of his biographies, of Justice Holmes and of Chief Justice Warren, have won the ABA's Silver Gavel Award. And, well, I could go on and on and on, but we need to get to today's business, since we only have about 20 minutes with Professor White today. Our topic is his article in the current issue of the Journal of Supreme Court History. The article's title is The Lost Case of Solicitor General versus United States, and it is a fascinating and amusing combination of procedural details, statutory interpretation, court culture, and constitutional law. So, let's get started. Professor White, welcome to Breaking History.
Thank you. Glad to be here.
And so, Professor White, what is this case all about?
Well, it started for me with a petition that was filed at the Supreme Court by the then Solicitor General of the United States, Philip Perlman. And accompanying the petition was a lower court opinion involving a case where there was an interpretation of a statute that was designed to protect the building and grounds of the Supreme Court. And the statute, among other things, prohibited a variety of activities that could have been described as expressive. For example, it prohibited a standing in place for people who were visiting the building and grounds. And most particularly, it prohibited speaking in a loud voice and engaging in activities that we would think would be utterly inconsistent with the idea that people were arguing cases before the Supreme Court itself, and the justices were hearing those cases, and the justices were conferring, and apparently on its face, all of those activities were prohibited. Moreover, the Supreme Court cafeteria was apparently affected by the fact that people were prohibited from standing in line to take out food from the cafeteria. So the petition asked the court to respond promptly on the theory to consider the validity of some of these statutory restrictions, given the fact that a number of persons were directly affected by the statute. Perlman said, among other things, in filing the petition, that he was concerned that a number of the people in his office that were participants in arguing cases before the court might have their professions put in jeopardy by being arrested for under this statute. But the lower court opinion concluded that the statute should be upheld, and the Solicitor General should be fined under it, because the statute had been obviously authorized by the court itself. The history of the statute was that there was It was introduced at the at Congress, and then there was a couple of reviews of it, but it had been introduced by the court itself, by the marshal of the Supreme Court, and so the petition claimed that these people operating lawyers operating before the court, and in particular members of the Solicitor General's office itself, were having their core functions basically criminalized by the statute. So it was a fascinating beginning, and I checked to see whether there was actually been a statute of that sort passed, and it turned out that it was.
My goodness. So was it in fact the case that this statute was upheld by the court below and that the SG's office, the Solicitor General, and all his deputies were at risk of criminal sanction for arguing cases before the court?
The petition was accompanied by an opinion by one Judge Stern, apparently associated. He was described as sitting pro haec vitae, which means sitting for on the occasion, but it was apparently a lower court in the District of Columbia, where, of course, the Supreme Court's building and grounds is situated. And yes, the opinion, 6 pages in length, reviewed the situation and concluded that under normal situations, the statute would prohibit, would violate the Due Process Clause, the First Amendment, and other other provisions of the Constitution. But that this particular judge, Judge Stern, felt that given the fact that the statute had been approved by the court itself, it would be transgressing on the dignity of the court for a mere municipal judge to invalidate it. So he left it intact, and he submitted the Solicitor General to criminal prosecution.
Oh my goodness. So what can you tell us about this Judge Stern?
Well, he's not identified, and I examined those records that would seem to indicate who municipal judges in the District of Columbia were at the time. I found no such Judge Stern. My suspicion, eventually I believe confirmed, was that he might have been a member of the Solicitor General's staff itself, and it turned out that that is who I think he was. I think he was Robert Stern, an assistant to the Solicitor General at the time. Stern was a very erudite fellow who had published some scholarly work, and would have been a good candidate. And the opinion is written in a very lawyer-like fashion.
So this Judge Stern, am I correct by this Judge Stern character would go on to be the co-author of one of the 2 leading treatises on Supreme Court practice?
Absolutely. Stern and Gressman. He is the Stern of Stern and Gressman, perhaps the leading a treatise on Supreme Court practice.
Oh my goodness. So this would have been early in Stern's career, and he is posing as a judge.
That's correct. That's correct.
That seems like a risky career move in its own.
Well, there's another suggestive thing about this, Ross. The petitions that Perlman writes, the cover letter, and he says in the cover letter to the clerk's court, the clerk of the Supreme Court, he says in the cover letter that it occurred to the brilliant minds on my staff that this statute might pose some kind of immediate threat to persons who were engaged in regular appearances before the court. I thought that would be a kind of unusual phrase in a usually formal cover letter, to the brilliant minds on my staff, and it made me think that perhaps the brilliant minds on the Solicitor General staff had been the authors of not just the petition, but perhaps Judge Stern's opinion as well.
Uh, are you suggesting that there was one or two senses of humor behind this filing?
I am. I am. The discussion of judicial review in Stern's opinion is quite hilarious. The discussion comes down at a time. This is the fall of 1941, when the jurisprudence of judicial review is changing, and the court is beginning to adopt a very deferential posture toward legislation that infringes on one or another provisions of the Constitution. That and the and the Stern's opinion reviews that, but suggests that under cases such as Caroline Products, there is an exception to the normally deferential posture where certain kinds of rights are involved. And one of the things that Stern says in the opinion is, surely there must be a due process right to move about freely. And this legislation prohibits standing, which would suggest that the only way in which people could move about would be to crawl on the floor. It also suggests that preventing standing at the Supreme Court cafeteria might mean that people would then rush toward the cafeteria in order to secure their food, which might lead to a breach of the peace. So there's this kind of dry lawyer's humor running through all of the documents that are filed.
But they were, in fact, in the papers of one or two Supreme Court justices, right? So this was not purely an internal jollification within the Solicitor General's office. These papers actually reached the court, right?
Absolutely, they were filed. The copy that I used was found in the Earl Warren papers. Now that is itself suggestive, since Warren was obviously not the Chief Justice at the time. What are these files doing in the Earl Warren papers? Mm. I conjectured that they were there because they were just being retained as a kind of exhibit of something that had amused the court at the time and might continue to amuse the justices. Warren, of course, as the chief, would nominally be a person that would have retained these sorts of documents. So I thought that was appropriate. No, this is my article concludes, Ross, that this is a hoax. This is a lawyer's hoax from beginning to end, and it is a way of intimating that this statute is complete nonsense, and needs to be thought through.
And this may well be a particularly appropriate time to ask this particular question, because your latest Supreme Court book is a new biography of Justice Robert Jackson. The nonsense of this statute, which was Public Law 250, I think, at the time.
That's correct.
That was numbering, right? In fact, at least a few of the justices, including Justice Jackson, did eventually conclude that, at the very least, much of Public Law 250 was not only nonsense, but unconstitutional. And you near the closing of your article, you talk a little bit about Jackson, what he would have thought of this, and what happened with it. So what did happen with Public Law 250, and How did Justice Jackson, one of the great thinkers and writers on the court, react to it?
Well, he actually quoted from it in another case in which he was trying to make the point that this was another case in which legislation, in which he believed that legislation was infringing on due process rights, and he was trying to make the point that the Supreme Court had apparently, with respect to its own building and grounds, ignored obvious constitutional problems in the drafting of a statute. And here's an analogous case in the court. You know, if the court is taking this supine posture for its own things, maybe it should consider whether that makes sense in another case. So there's a pretty lengthy excerpt I quote at the end of the article in which Jackson suggests that much of Public Law 250 was in fact unconstitutional.
And where does that law stand today?
Well, it's virtually nugatory. I suppose that the features of Public Law 250 that try to restrict the movement of traffic, visitors, in the court's building and grounds might be upheld to the extent they're not too restrictive of freedom of movement. But the prohibitions against standing and speaking in a loud voice are clearly unconstitutional. One of the points that Judge Stern makes is that
And now here we're talking about Judge Stern, right?
right,
Yes.
right, that Judge Stern makes is that the people who are charged with violating the prohibition against speaking in a loud voice defended it on the fact that some of the people that were part of the conversation were hard of hearing. And so which required them to speak more loudly. Obviously, the drafters of the petition were thinking about members of the public interfering with Supreme Court arguments or something, but the way in which they drafted it opened up this possibility. Oh, the one other point I want to make, Russ, is that there was an earlier provision restricting the same kinds of activities with respect to Congress and with respect to the building and grounds involving Congress. And whoever was responsible mainly for drafting Public Law 250 just copied this randomly without thinking at all about the differences between applying prohibitions against standing and speaking in a loud voice to persons who were arguing cases before the Supreme Court.
What does this tell us about the culture of the Supreme Court in the mid-20th century?
Yes, at this point in the court's history, the Solicitor General's office and the court have very close relationships. The Solicitor General is before the court all the time. Its staff members are arguing cases. The justices are well aware of the people that that are appearing before them, the lawyers that are appearing before them. The Solicitor General's office has emerged as an elite institution attracting very high caliber people. Jackson, when he becomes Solicitor General, says that he believes that office to be the most coveted one in the legal profession. It's a very professional staff, and their regular appearances before the court suggest that they develop relationships with the individual justices that go beyond the sort of formal contacts where somebody's just arguing a case. That is to say, these are people that spend a lot of time before the justices know them well. My father-in-law, John Davis, was with the Solicitor General's staff for many years, and he had very close relationships with several of the justices. In other words, Ross, it's the kind of context that would permit close acquaintances to have a mutual joke. And that I am quite sure that when when the members of the court saw this petition, some of their first responses would have been to laugh out loud. I wouldn't say that that's the current perception. I would say the current perception is that the Solicitor General's office and the Attorney General's office are doing the current administration's bidding, and the justices seem to be aware of that. So I think, in short, something of that closeness and sort of commitment to legal craftsmanship has been lost.
And in addition to that closeness, there's also the sense of humor aspect of this. This could have been done in more than one way, and they did it with what is, in fact, a very well executed, what might almost call a pseudo hoax. And going back to the Marshall Court, about which, how many books have you written about the Marshall Court? 2, 3?
Well, some.
Some. We'll call it some. At some more general level, it reminded me of the anecdote about John Marshall and whether it was appropriate to have a glass of port while they were in conference, and that they only did that, or was it Madeira? But they only did that when it was raining, right? And so how did his line go about that?
Well, the Marshall would say that the question would be raised about whether the justices could open up some Madeira, and they look outside the window and they realize it's not actually raining in Washington. And then Marshall is reported to have said, well, the jurisdiction of this court is extremely wide, and I believe that somewhere in our jurisdiction it must be raining. So Marshall had quite a good sense of humor himself. And of course, now you have to remember, Ross, that the court in Marshall's day they're living together in a boarding house. They're meeting, they're having informal conferences as the arguments progress. They'll go back after an argument. The arguments aren't restricted in terms of time, so some of the arguments are very lengthy, 3 days sometimes. But in the middle of the argument, the Marshall Court justices will go back and start deciding the case, and in a very informal setting. So very conducive to this kind of humorous and informal interchange. And that's what's reflected in this petition and quote, Judge Stern's opinion.
So this this combination of professional and personal proximity with bright people who understand both the importance of their mission and their importance of dealing well with each other results every once in a while in something downright crazy that we get to publish in the journal.
I say in the piece that this petition and Judge Stern's opinion was drafted late in the summer before the term had opened up, and I speculate that this staff is getting ready to gearing up for the term, gearing up for advocacy in the term, and they encounter this statute, and for some fun, and to communicate the fact that who were the nitwits who drafted this, that they decide to do it, and Perlman, of course, is on board with it. So it was a absolutely delightful project for me to work on.
Thank you very much for joining us for this edition of Breaking History. We will be back soon with another new and interesting look at the past. Thank you very much.